Hey all you cool cats. I want to give you a heads up that there's going to be some changes in the composition of the court structure, which you'll see. I have made those changes. When the slide comes, there's a bunch of new pictures, but we did lose Ruth Bader Ginsburg, so we'll see what happens.
Hey guys, just a couple of slides, about 10 slides on the Supreme Court of the United States. I think it's really important for your assessment this week to talk about some of the key features in the United States Supreme Court. First, just some characteristics of the Supreme Court. In the United States, the Supreme Court is going to be the court of last resort, which means that once the Supreme Court has ruled on a particular issue, that's kind of the end-all be-all. Congress can try and rewrite a piece of legislation if it's been declared unconstitutional, but for the most part, unless that's something that they're willing to do, it's kind of, this is the cap on what happens. It has the final interpretation over the Constitution, which means that if there is a question about some sort of interpretation of the Constitution of the United States as well as the constitutions of the states, once the Supreme Court has interpreted it, that's going to be the last arbiter of that. There's nothing higher you can go. So, for instance, you can take a question to a district court or a state Supreme Court, like the Texas State Supreme Court, and if you still are unhappy with the way that they've interpreted the question or the statute, you can take it to the Supreme Court, and if they're willing to hear it. But once the Supreme Court has heard that argument, there's nothing higher. There's no higher authority that can change their decision. And based on the Supremacy Clause of the United States, no state constitution can run contrary to the federal constitution because the federal constitution weighs supreme. So, for instance, if the state of Texas decided to put an amendment allowing slavery to exist, because the Constitution of the United States prohibits that kind of discrimination and discriminatory practices, it would be unconstitutional for the Texas Constitution to re-implement that. As well as the Supreme Court is a appellate court. So with the exception of like 3 exceptions on state to state and United States and foreign suits, the Supreme Court does not hear new facts. It is not a trial court. Anything that they've been showing before has already been testified before at a lower court. No new facts. They're strictly trying to determine whether or not the law was applied correctly. And this is going to be the makeup of the Supreme Court.
Okay, so that clip was about to show you the makeup of the Supreme Court, which would be as you see here. However, this has changed with the death of Ruth Bader Ginsburg. May she rest in peace. Ruth Bader Ginsburg will soon be replaced, maybe, with Amy Coney Barrett. This is something that you've probably heard a lot happening in the news, considering the current zeitgeist right now. The question is whether or not the president has the ability to nominate a Supreme Court justice that sits for a life tenure during an election year, especially considering we have less than 2 months. Now, in 2016, Obama attempted to replace Antonin Scalia with Merrick Garland during an election year, and the Republicans refused to allow that to go through and replaced him once Trump was appointed with Neil Gorsuch. And so this is kind of the tables have turned situation, and people are questioning whether or not we should wait until after the election to appoint a new justice. That's the controversy, also because the replacement of Ruth Bader Ginsburg would make the court significantly more conservative. It would basically give a 6-3 majority to the Conservative Party. And that's that. Now, if you have other questions about this, because I could talk about it all day long, but I don't want to give you too much information, let me know. I'm happy to provide you any more clarification.
Some pictures. This is your Chief Justice, John Roberts. And the Chief Justice role is largely just administrative. He makes sure that everybody's working in a timely manner, helps to implement the docket, but other than that, he doesn't hold any more weight in his decisions than any other justice. And again, these are the only ways in which new facts or testimony is heard at the Supreme Court level. That is, the Supreme Court only has jurisdiction if it is between 2 or more states. between the United States and a state, between a foreign ambassador and a diplomat, or if it's between citizens and a state and a citizen of a different state. So the state of Texas versus a citizen of Illinois or something. And it is initiated by the state. So if the state is suing a person. They have appellate jurisdiction over everything else. And one of the key elements of the Supreme Court is the idea of judicial restraint versus judicial activism. Okay, so we've talked about the idea that the Supreme Court is the least democratic branch, which is to say that they are not to be held accountable to the people. They are not elected by the people. They're not subject to the will of the people in any way. Their role is completely disassociated from the populace by people of the electorate. They are not interested in what society necessarily wants their ruling to be. There should be, ought to be interested only in the interpretation of the Constitution, right? So if the interpretation of the Constitution is in such a way that may be unpopular, that really doesn't need to affect the outcome of their decision in any way. Although the decision will be unpopular, it is the right thing in terms of the Constitution. They are not subject to re-election. They have lifetime tenure. And so in that way, it is supposed to be the least democratic branch for a specific reason. They don't want democracy or the will of the people to influence the interpretation of the Constitution and their rulings. And in that way, when judges practice judicial restraint, they are reflecting that idea that the United States Supreme Court is the least democratic branch. Even though the law might be unfair or unwise, it's not necessarily a good law, it's not necessarily unconstitutional. And so, on contrary to that, somebody who practices judicial activism might not necessarily accept that that element of being the least democratic. Again, a justice who practices judicial restraint views the Supreme Court as being the least democratic branch, and will say, although this law is unwise or it is unfair, it is not unconstitutional. And they rely largely on the original intent of the Constitution. So they'll look at the Constitution and say, what did the Founding Fathers intend this to be? What was the actual intent of the piece of legislation? And what have prior courts, or stare decisis, what have prior courts said about this intent? Things like Dred Scott v. Stanford, Plessy versus Ferguson. These were all rulings that were consistent with the idea of judicial restraint. They say, if you don't like the idea that separate and equal, which was the ruling in Plessy versus Ferguson, in which they said separate was equal. If you don't like that doctrine, you don't need to come to the Supreme Court to determine whether or not it is constitutional or whether or not it's fair. They argue that it is constitutional based on the original intent of the document of the Constitution. If you don't like that, don't come to the Supreme Court. Go and re-elect or elect legislators that are against the idea of separate versus equal, and have the change come from the legislative branch rather than the judicial branch. I hope that makes sense. So don't use the judiciary as a way to legislate. When the doctrine of separate versus equal is not necessarily unconstitutional, although it is unfair, the intent was not unconstitutional. And because prior courts have upheld this as constitutional, we're going to keep consistent with that. And if you would like to get rid of that doctrine, elect legislators who will do that for you and have that change come more slowly through the legislative branch. On the other hand, several people believe in judicial activism, and they believe that the Constitution was malleable and was intended to be a living document that should change and be adjusted, not necessarily change, but reinterpreted through changes in society. Certain things that might have outgrown society can be reinstituted through the Constitution. and that the founders actually intended for it to be a living document because society's needs changes, and as society changes and grows, so should the document, and that's why they intended it to be so short and so vague in many cases. And so they shape the constitutional meanings of certain things to fit the contemporary needs of society. Okay, so if we look at the changing meanings of, for instance, the Second Amendment. At the time, we did not have a militia, and so the Second Amendment fit the idea of not necessarily of defending yourself. But now that we do have a state militia, the meaning of the Second Amendment might be reinterpreted. And they will vigorously review the actions of the other branches for their constitutionality, and that's called judicial review, where they look very vigorously at acts of the president and acts of the legislator with a very critical eye and review them for their constitutionality. Judicial activism tends to bring sweeping change. Things like Brown versus Board of Education, Roe versus Wade, the same-sex marriage case here. And people who are in favor of judicial activism make different arguments about them. They say judicial activism is necessary to correct certain injustices that might not have been a problem in prior, they might not have presented itself as an issue until recently. For instance, same-sex marriage. It's correcting an injustice that didn't necessarily have precedent before this. And activism should be used as a last resort when there's gridlock between the executive and the legislative branch, or if the executive and the legislative branch refuse to act. So, by way of example, Barack Obama implemented an executive order on immigration, which is necessarily an issue for the legislative branch or Congress. But because Congress refused to act on that, the executive branch was forced to create that executive order. And in this case, when that executive order was reviewed for its constitutionality, the Supreme Court did say, no, this is a job for the legislative branch. On the other hand, people who favor judicial restraint will say things like, the power to make laws or change the way laws are is for the legislative branch. And so if the court intervenes and changes these laws, like they would do in things like Brown versus Board of Education, or looking back Roe versus Wade, things that implement sweeping change really shouldn't come from the judicial branch. It needs to come from the legislative branch, because judges aren't equipped with the background necessary to enforce these social policy changes. They are not democratic. They are not responsible for the will of the people. And that is outside their realm of influence. Here's a really good picture that helps to identify that. These are rulings. Let me get my little pen out. Or I could use, oops, I'm sorry. Let's see. These are cases that really championed the idea of judicial restraint, right? So, really involving itself very little with legislative things. Plessy versus Ferguson upheld the doctrine of separate versus equal. Dred Scott, the 3/5 compromise, things like that. And then, if you look over here, we change to an idea of judicial activism. And this happened right about the time of the New Deal. And the New Deal, I've said it before, I'll say it again, can be a benchmark or a marking point in American history for a sweeping change in American society. So at this point, we have a lot of people who really need to experiment with the ability of the federal government to influence change in American society, largely because of the Great Depression. The federal government had to absorb a lot more power to help correct some of the social injustices at the time. You have sweeping changes because of a very active Supreme Court, like Brown versus Board of Education. Separate was not equal. Okay, Bush versus Gore. That was an electoral college one. Roe v. Wade regarding abortions. District of Columbia versus Heller. Second Amendment rights. All of these things make sweeping changes in American society. In fact, you can add several more of them. Johnson v. Texas. right here you would add something like, ooh, I guess that's probably way too far over, but the same-sex marriage case. Excuse me. But one thing that was pretty interesting that took place in about, right about here, next to this one, was, I think it was 1991, and the case was San Antonio v. Lopez, and that was the first time in several years when the Supreme Court finally kind of put a cap on its own power and gave power back to the states to implement as they feel fit. So you can see it kind of goes through changes based on who's on the Supreme Court at the time. We had a very classically liberal case, a Supreme Court here, and if you'll think back to when we discussed ideologies, classically liberal associates itself largely with the conservatism modern day. And so these conservative justices tended to want to restrain their interpretations of certain things. And then we have a change to a very modern day liberal, modern liberal understanding of the Constitution, in which they understood it to be more of a living document, except for these two very specific cases in the middle in which they reverted back to classical liberal interpretations. I hope that wasn't confusing. I found that fascinating. This is one of my favorite things to research. So let's move a little forward. A couple other things about the Supreme Court is there are actually no formal qualifications required by the Constitution to sit on the Supreme Court. 1/2 of all the justices during the 20th century absolutely had no prior experience as judges. Now, that's not to say they didn't have prior experience as attorneys. They might have, but there has been a couple of cases in which they did not have a law degree. Robert Jackson sat from 1941 to 1954, and he didn't have a law degree, although he did pass the bar. Stanley Reed was the last person to leave the bench without a law degree. He left in 1954. And Joseph Story didn't have any prior legal experience, but he was he was a savant, I suppose. He was 32, and it was in the early inception of the United States. So we do have cases where we didn't have lawyers, attorneys, or judges. And I have this joke here. What are the qualifications? So, real quick, how the Supreme Court actually works is that an attorney will issue what's called a writ of certiorari, in which it asks that the Supreme Court review the decisions of a lower court. They could also do it in a way of writ of habeas corpus, which is bringing forth a body or demanding to have a court hearing, or writ of mandamus, in which the attorney will ask for the Supreme Court to look at, to issue an order of them to act in a certain way, or stop acting in a certain way. And if the court agrees to hear a case, it'll come before. But the court is under absolutely no obligation to hear any particular case. They are allowed to choose their docket, which means generally if it doesn't hold an important constitutional rendering, they probably won't hear it. They accept about 100, 150 cases, and I think way more than 7,000 cases it's asked to review. So it has the ability to hear it, and usually it'll hear things that are of public importance at the time, or maybe there's been they'll hear several cases of this 7,000. There are several very important ones of the same matter, and so they'll choose the most important, and then that way they'll able to cover some of the other questions here. And they begin with about 30 minutes of oral arguments on each side by the attorneys, and then the justices will discuss under closed doors. So really the hearings are very, very short, and the judges do most of the research behind closed doors in their own. And you'll never see a video footage of the Supreme Court in action, because cameras are not allowed in the Supreme Court. Only recently did they allow audio devices, and shortly before that they allowed people to carry pens and markers in. So it's although it's free for everyone to go view in person, they don't want people or the judges to be influenced by being recorded. They fear that maybe people try and talk to the camera, or it'll intervene on their judicial autonomy. And then people also argue the contrary, saying that it'll help people be more educated about the judicial process. So there's cases back and forth, but what you can hear is the transcripts or the audio, but you won't ever see live video. I'm going to skip this one because I just said it. After the oral arguments, the justices will meet and they'll reach a decision. They'll talk to each other about it. They will do a lot of research. And then they will issue a formal document with an opinion on that. The opinion is a number of things. They can have a regular concurrence or a special concurrence, which means that they've decided to go ahead and agree with another justice. And they can have a special concurrence or a dissenting opinion in which they'll say, I agree with you, but I got there differently. The dissenting opinion is usually a minority opinion. And these are just some special legal terms. We don't need to go over them. You can look at them in your own time if you'd like. But that's all I have for you on this slide, guys. I hope you have a great week, and I hope that was helpful. But please let me know if you have any questions.